Good afternoon. Thank you for joining us today. Today is Monday, July 13th, 2026. We are here for our 3 p.m. land use hearing, as it is our tradition and way we start and begin our meetings and open the meeting is with a pledge of allegiance. Please join me as you're able. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you again for joining us for the Pledge of Allegiance and welcome. We're all glad you're here today. My name is Larimer County Commissioner Jody Shab-McNally, and I'm the Chair of the Board of County Commissioners. Again, welcome to our meeting. I am joined at the dais by Commissioners Kristen Stephen and Commissioners John Kafalis. Also, we have our clerk and recorders. From the clerk and recorder's office, we have, for taking notes for us and recording the meeting, is Deidre O'Neill. Deidre, welcome. So nice to have you here. Thank you for your diligent work. And of course, we have across the way, we have from our county attorney's office, we have Frank Haug. Hello, Frank. Happy Monday. And then we have several folks at the dais, but I'm going from other county departments in the room. We have quite a wonderful gathering of amazing staff. And so I'm going to just turn this over to Jenny Axmaker, who will, our planning manager, for introductions of everyone and to share some hearing procedures, instructions that are important before we proceed. Thank you, Jenny.
Thank you, Madam Chair. Joining me at the dais, we have Jared C., one of our county planners. We have Amy White, our code compliance supervisor. We have Ryan Oswendell, who's part of our planning administrative team. And then across the way, we have a whole group of staff. We have Sam Lasher, JC McNulty, Justin Curry, all from our county planning group. We have Bruin Johnson and Connor Sheldon from our engineering department. And we have Ashton Brodel from our health department. So with that, I would like to give a brief introduction. We respectfully request that all members of the audience silence their electronic devices. Please help yourself to a copy of the agenda and hearing procedure instructions, which are located on the wall just to the right of the hearing room door, or if you're joining us online, you can find it on our website at larimer.gov/BOCC/commissioners-meetings. Please wait to speak until recognized by the chair. Please maintain civility, refraining from audience applause, comments, or disruptions, whether positive or negative. Please make all comments to the Board of County Commissioners from the podium. A portable microphone is available if needed. Please state your name at the beginning of your comments and provide the spelling of your name if it's unique. Please speak directly into the microphone so that remote participants may hear. The microphone on the podium can be repositioned to best capture your testimony. You may ask questions during your testimony, but those will not be answered until public comment is closed and rebuttal has begun. Upon request, we do have assisted listening devices available for the hearing impaired. For those on Zoom, attendees will be muted until they're recognized by the chair. If an online attendee wishes to speak or requests that an item on the consent agenda be removed, please use the raise your hand function on the Zoom control bar or *9 on your phone. Thank you, Madam Chair.
Thank you, Jenny. I appreciate all of that. And so now I'm going to go through some additional information, including what is on our agenda today. So first, I'm just going to list the clarifying what is on the consent agenda and then also is on discussion items. But this is what is on our agenda today. We have, under our public hearing consent items, we have number 1 is an extension of the data center moratorium. We have 2, the Bartell easement vacation, file number 26-LAND 4554. Number 3 is Meadows at Prospect Storage Appeals, file number 26-GNRL 0585. And lastly, number 4, we have the Colwitter Appeal, file number 26-GNRL 0587. We also have 2 public hearing discussion items. The first, and those will be heard later after the consent agenda items. This is the, we have first HB 26-1239 rubbish ordinance update, first reading, file number 26-CODE 0293. And then number 2 is the ACOT amended plat and boundary line adjustment and easement vacation, file number 26-LAND 4538. So now I'm going to go back to our consent items, which typically items on the consent agenda are considered routine in nature, and as far as we know, there is no perceived significant controversy, and items on the consent agenda will not have a staff presentation. The applicant will not get to speak, and there will not be an opportunity for public comment unless the item is pulled from the consent agenda. Commissioners are able to pull an item from the consent agenda as well as the public. And if that occurs, then there will be a presentation, public comment, and the rest of the procedure. For items on the discussion, as I said, there will be a presentation from staff and an opportunity for the applicant to make their case, and there is an opportunity for public comment. And after that, the applicant and then the staff can make a rebuttal to the public comment, and commissioners can, commissioners can then ask questions and ask and listen to public comment. So for that, we are looking now at just the consent, and there will be a full presentation basically with the discussion items. And so we'll have deliberations, and then we'll make a decision with discussion items. But really, we're first, and thanks for listening and for what's really first on our minds to get through for today is the consent agenda. And I'll first ask the commissioners, do you wish to pull any items off the consent agenda? Okay, now I'm going to ask the public, as I listed those 4 items from the consent agenda, does anyone in the audience or anyone online wish to pull an item from the consent agenda? Please raise your hand to make your way to the podium to identify which item you would like to pull. Ryan, can you tell me if there's any indication online?
If anyone would like to remove one of these items, please use the raise your hand function or *9 now. We have no hands raised.
Great. So I will now ask Commissioner Cafals, would you please make that motion to approve the consent agenda? Is that a hand raised?
Yeah, sorry, I was just curious because no one really gave any information. What is the Bartel easement thing? What is that actually vacation?
Frank, is that something I can answer? Would you like to?
Well, I mean, all of the information has been available. There's an agenda right up here, but it's going to vacate an easement. If you want to discuss that item, right now what's about to happen is the board's about to pass a motion on the consent agenda, meaning that'll be the end of it. It'll either get approved or not approved.
So is it like someone vacating a premises or like?
No, it's like in that particular case, I think it's just like a utility easement that's getting vacated. Whose is, yeah.
Yes, that is correct. They're just proposing to vacate an existing, I think it's like 14-foot utility easement on the property where no utilities are currently present.
And normally we would not have public comment during like this, but I'm going to go ahead and allow that today just for help, but just in case we did, only to allow it to see if you wanted to pull it, but it is routine in nature.
Sorry, it's my first meeting.
No, it's fine. I just wanted to say, usually we don't allow so, but I appreciate you wanting to learn more, and certainly you can go to the Board of County Commissioners website, our agendas and our meetings and all these items, and even our meetings for tomorrow's admin direction, all the details and amounts are all on there. So we appreciate your interest and your curiosity. So Commissioner Cafals, I still don't see anybody who wants to pull those items, so would you make that motion to approve the consent agenda as presented, please?
Yes, I'd be happy to, Madam Chair. Good afternoon, by the way. Welcome, everyone. I move to approve the consent agenda, the 4 items listed on the consent agenda for Monday, July 13th, 2026, subject to any conditions of approval as set out in the staff reports, and further authorize the chair to sign the findings and resolutions for the applicable items.
Thank you for that motion. Any further deliberation?
Nope.
All those in favor? Aye.
Aye.
That passes 3-0. That consent agenda is approved. For those of you that were here in the audience, for those consent items, you are welcome to exit the room now if you'd like, or if you'd like to stay for the rest of the public hearing, you're welcome for that as well. Thank you all for being here, and thank you, staff. Appreciate your work. So now we're going to move on to our discussion items, and the first item is number 1 for our public hearing discussion items, HB 26-1239, the rubbish ordinance update for the first reading for file number 26-CODE0293. Amy, I'm assuming this is for you to read.
That it
Please
is.
proceed.
Good afternoon. My name's Amy White. I'm the Code Compliance Supervisor here at Larimer County. And just by way of background, during the 2026 legislative session, House Bill 26-1239, entitled County Enforcement Authority, was passed and subsequently signed into law on May 29th. The new legislation revised state-level requirements, prompting necessary amendments to the recently revised rubbish ordinance. So here's a brief summary of those changes. It extended the warrant timeline. The deadline to execute an entry and seizure warrant for rubbish removal has been significantly extended from 10 days to 30 days after the issuance. It expanded right-of-way authority. We now have the authority to compel property owners to remove rubbish from the public right-of-way immediately adjacent to the property. It increased the administrative cost of recovery. So previously for an entry and seizure warrant, we could recoup 5%. That has been up to 10% at this point. And it also allows us to collect a $10 recovery fee for court-ordered cleanups as well. It expanded our zoning and building code enforcement. The bill targets the unlawful construction, alteration, or use of buildings and land that violate local county zoning regulations. It streamlined our legal remedies and higher fines. That's set out in the bill itself. And then enforcement personnel, the bill also expands who can serve a summons for a code violation to include local zoning enforcement personnel, removing the sole burden from the county sheriff. Specific changes include the following. So this is going to be the first reading, and what I did is went through the ordinance and just pulled out what was new instead of reading the whole ordinance. The second whereas clause is amended to read, whereas the board has previously adopted local ordinances concerning the removal of rubbish from lots and tracts of land within Larimer County in both Ordinance 06-2020-17001, dated December 5th, 2026, and the amendment to ordinance number 06-2020-1700001, dated March 11th, 2019. And then this language was added, and the Larimer County regulations relating to the accumulation and removal of rubbish, dated March 26, 2026. A third whereas clause was added as follows. Whereas House Bill 26-1239 was signed into law on May 29th, 2026, with an effective date of August 12th, 2026. A fourth whereas clause was added as follows. Whereas House Bill 26-1239 expands county enforcement authority over property violations by adding civil penalty and injunctive relief remedies, extending the warrant execution period to 30 days, and broadening the scope of rubbish removal authority to include adjacent right-of-ways. And then Section 1 of the ordinance, authority, was amended as follows. It removed the existing language and will now read, this authority extends to rubbish on any lot, parcel, or tract of land within unincorporated Larimer County, as well as to any public right-of-way immediately adjacent to such property to the extent the condition is caused by the property owner or occupant or originates from the property. The reasonable costs incurred from such removal by Larimer County may be assessed upon the property from which rubbish has been removed and collected in the same manner as other taxes. Section 3, scope of ordinance, was amended and will now read as follows. The ordinance shall apply within the unincorporated territory of Larimer County, Colorado, this is the new language, including any public right-of-way immediately adjacent to property within the county to the extent a rubbish condition is caused by the property owner or occupant or originates from the property. However, pursuant to CRS Section 30-15-401, 1.A.I.A. This ordinance shall not apply to industrial tracts of land that are 10 or more acres in size or to agricultural land currently in agricultural use as defined in this ordinance. Section 6, violations of this ordinance. The existing language was removed, and this language will now be in its place. It shall be unlawful for any property owner to allow the accumulation of rubbish on any lot, parcel, or tract of land, or on any public right-of-way immediately adjacent to such lot, parcel, or tract of land, to the extent such condition is caused by the property owner or occupant or originates from the property in the county except industrial tracts of 10 or more acres and agricultural land which are excluded from this ordinance. Section 6, procedure for notice of violations of this ordinance. Section B of that section was amended as following. The following two subsections were added. Subsection B, describe any potential enforcement authority of the county, including any possible liens that may result from abatement costs and any civil penalties that may be imposed pursuant to CRS Section 30-15-401.2.d as in effect now and hereafter amended. Subsection C was added, and it will read, identify whether the violation exists on the property, on a public right-of-way adjacent to the property, or both, and if on a public right-of-way, describe the basis for the county's determination that the condition was caused by or originates from the property owner or occupant. Subsequently, that required the former Section B to move to subsection D. And then further down, and same with C, now becomes E. Subsection I.1 will now read, if a hearing is requested by the property owner pursuant to Section 6.B, the date of any requested hearing shall be as soon as practicable, considering the board's calendar. Written notice of the date of the hearing shall be sent via first class was removed from this verbiage, mailed to the property at least 7 days prior to the date of the hearing. Section 7, administrative entry and seizure warrant. Subsection B, subsection G has been added and will now read, if the rubbish to be removed is located on a public right-of-way adjacent to the property, evidence establishing that the condition was caused by the property owner or occupant or originates from the property. Subsection F becomes subsection H, subsection G becomes subsection I. And then subsection E of section A, costs of removal. The existing language was removed and will now read, all reasonable costs associated with the removal of rubbish and impoundment, if ordered by the court, shall be paid by the property owner. An additional 10% of those removal costs shall also be assessed to cover inspection and other incidental expenses. Section 8, civil penalties and injunctive relief was added as follows. Subsection A, this is a whole new section. A, civil penalty enforcement. Pursuant to CRS Section 30-15-401.2.d, as in effect now and hereafter amended, in addition to the warrant and abatement procedures set forth in Section 7 of this ordinance, the county may seek court-ordered civil penalties against a property owner who fails to abate violations of this ordinance after written notice as provided in Section C. Subsection A of Section A, upon a property owner's failure to abate a violation after written notice as set forth in Section 6, the county may request the county court or district court of Larimer County to impose a civil penalty of not less than $100 nor more than $2,650 per day of the violation. Each day a violation continues is deemed a separate offense, and the penalty continues to accrue until the violation is fully remedied. Subsection B, any civil penalty ordered by the court and unpaid shall, as of recording, be a lien against the property on which the violation has been found to exist. If an assessment is not paid within 30 days, the county clerk and recorder or county attorney may certify the non-payment to the Larimer County Treasurer, who shall collect the assessment together with a 10% penalty for the cost of collection in the same manner as other taxes are collected. Any such lien must be recorded with the clerk and recorder of Larimer County. For purposes of this section, property owner does not include a state agency. Section B was added, injunctive relief, and court-ordered abatement. In addition to civil penalties, the county attorney may bring an action in the county court or district court that has jurisdiction over the property for an order enjoining a violation, ordering the violation's restraint, removal, termination, or abatement by the property owner, and authorizing abatement by the county or its agent pursuant to CRS Section 30-15-401.2.d.4 as in effect now and hereafter amended. Subsection A, to bring an injunctive or abatement action, the county attorney shall file a verified complaint. The court shall review the complaint, schedule a preliminary hearing no later than 30 days after the complaint is filed, and direct issuance of a summons stating the date, time, and place of the hearing. The county shall serve the summons and complaint on the property owner in accordance with applicable rules of civil procedure at least 10 days prior to the hearing. Subsection B, if the county is unable, after reasonable effort, to personally serve the summons and complaint, the county may post the summons and complaint on the property and mail them by certified mail with return receipt requested to the property owner's address in the records of the Larimer County Assessor as an alternative service. Alternative service must be completed at least 10 days prior to the preliminary hearing. A property owner's failure to appear at a duly noticed preliminary hearing is grounds for the court to enter a default judgment against the property owner. For good cause shown and prior to enforcement, the court may set aside an entry of default and the judgment entered thereon. Subsection C, if the county abates a violation pursuant to the court order, the actual costs of abatement plus 10% of such costs for inspection and other incidental costs shall be a lien against the property until paid, with priority over all liens except general taxes and prior special assessments. If unpaid within 30 days, the county clerk and recorder or county attorney may certify the non-payment to the county treasurer, who shall collect the assessment together with a 10% penalty for the cost of collection in the same manner as other taxes are collected. Section C, non-exclusivity of remedies. The county attorney has the discretion to determine whether to pursue civil penalties, injunctive relief, the warrant/abatement process, or any combination or any remedies available at law or in equity. None of these remedies are intended to be mutually exclusive. So that basically left some some record. So the former Section 8 now becomes Section 9. Former Section 9 now becomes Section 10. Former Section 10 now becomes Section 11. And Section 11 now becomes 12.
Also, we have 25 crossed out and be
Oh,
2006.
Thank you, Commissioner. Yes, and we updated the date from 2025 to 2026.
Thank you. Sorry, I
Yeah,
just thought
that's okay.
make sure we get that changed.
Yeah.
Thank you so much. So that has now been read. Frank, is that we've read it and now we move on?
Oh, can I speak on this?
No, you may not, sir. Please, you may not speak on this. This is, we're going to have this discussion and we'll call for public. I don't think, are we doing that this one?
We have traditionally done public comment on
Okay.
these. You do have to discuss the item on the agenda, however, and the comments need to be related to the item on the agenda.
Okay. So are we, so we can go ahead and open for, so you can sit down until I call for public comment, please? Yes, I wanted to, that's what I'm going to ask Frank is, should we have some questions?
That's up to the board.
And then call for public comment, which would allow for 3 minutes only for that public comment. And so, so should we go ahead and open for questions to see if, I see Commissioner Falls had a question?
Yes, thank you, Madam Chair. Thank you all for being here. I have two questions. One is, I apologize, but I did not have a chance to proofread this new language. I'm trusting and presuming that a couple of sets of eyes did proofread this language.
Yes, Commissioner. Christine Luckison in the County Attorney's Office, Mr. Haug, and also Rebecca Everett, our Community Development Director.
Excellent, Amy.
Sir, I have to say, please, right now, there is no comment from the public. There will be a public comment moment coming up. There will be no more outbursts from the public. We're going to ask our questions, and then there'll be a chance for the public to come up and make a public comment. At that time, you would have 3 minutes. I would ask you not to interrupt again, please. We're trying to do our procedure. Thank you.
So I just have one additional question, and that's all from me, and that is, would you further explain the process unless you did that in the beginning? In other words, we're doing first reading. What does this mean, and what happens next, for the sake of the public?
Certainly, and I will defer to Frank on some of this, but we now publish it for 10 days in a newspaper of general circulation. If we don't receive any comments from that period, we will come back for a second reading on August 10th. And if there's no comments at that point, we will publish the ordinance for 30 days, and then it becomes effective 30 days after the end of that 30-day publication date.
So August 10th is considered the second reading of the ordinance?
That is correct, Commissioner.
Great, thank you.
Commissioner Stevens, do you have any questions? I just wanted to ask Amy and Frank, just for the public's knowledge, any kind of document like this usually has several sets of eyes that reads it and proofreads it. So I just want to make sure that the public knows that's our standard. So, okay. So at this time, Frank, go ahead and have public comment, and we're going to have public comment. You will have 3 minutes. As stated earlier, Jenny Axmaker said that you direct the comments to the Board of County Commissioners. You will need to stop speaking at 3 minutes. And you need to identify yourself and where you're from at that time and state your name and spelling it for the clerk, please. Thank you.
My name is Nicholas Castell, Castell. I have a couple of questions. Well, the first thing I'm curious about is, like, if I walk into a meeting, how come all the information, why isn't there a big thick packet with all the information? You know what I mean? Is the first thing. And then my second thing is, like, are these all empty seats that normally would be filled? And can anyone like myself apply? Because the biggest problem that I see in this room is that there's a bunch of people that
Sir,
are established in this community.
So, sir, you're supposed to be addressing to items
Well,
that are on the agenda.
All right, so then I'll get to the point. Does Larimer County really feel as if they have the power to be, let's call it, it's not a rubbish ordinance, it's a what do you want to call it? Homeowners association. It's a county ordinance. You know what I mean? But it's like, my challenge is this: what are the benefits to us? Because it sounds like a Karen ordinance. Like, if I own a piece of property, which I don't, and that's my point, is that there's no one speaking for the little people anyway. But it's like, I can't use my property how I see fit. So it's like, if I have all these people around me that are like, oh, I don't like him, you're telling me that I would, basically someone could go to the court and say, oh, they don't like this, I could get tax charged and then cause all this trouble for me. You know what I mean? It's like, it seems crazy. It's like, so then what do I got to build a giant wall around my entire property? You know what I mean? Just so people mind their own business. I'm just trying to understand, and so back in the day, we all, in Greece times, right? We all went into society saying, because these are the benefits, we're protected, we're not attacked. So what are the benefits to the people in this ordinance? You know what I mean? It's like, I feel like, I just don't understand how we feel like things can be controlled like that. It's like, I don't feel like it's not right. Yeah. I don't feel like the county has the authority to be able to, just act that way in any way, shape, and form. It's like, were there not benefits to living out of city limits, and now you're saying that the Larimer County, and it's like, is there a minimum amount of chairs that can be closed for this to, you know what I mean, not run in a meeting? Because it's like, normally when you go into a meeting, right, and if it's a public meeting, all the all the information is, you know what I mean? But it's like, you guys are just like, every question I ask, it's like it's a problem. And it's like, I'm just a guy here for his first meeting. I have an interest in city council. I know that sounds crazy to you. Oh no, homeless guy wanting to be on city council. But it's like, I just,
Thank you for your public comment. Your
yeah,
time is up.
very welcome.
So, I'm not sure, Frank, if you want to address, we do have the county authority to do that.
Yeah, we are allowed to do all this by statute.
And the reason that we have certain chairs up here is because sometimes planning commission meets up here, and this is the dais where the board sits, and this is where we sit, not the public. And so we are, this is allowed to have these chairs. And sir, you may not speak again. You're disrupting a public meeting. There's a code of conduct thing on the wall and the entrances of all the buildings, and those are the code of conduct. So thank you for your public comment.
I meant no disrespect, sorry.
Okay. So, thank you all. Thank you all for being here. Thank you. So we're going to move on. So now you've explained the procedure, and Frank, we have done our due diligence as by law and by how we proceed with resolutions, and so we're all set.
Correct. You have to, I think, Amy, I think you moved to approve it on first reading, right? Or do they not?
I think it's,
I think it's the second reading.
yeah, I think it's the second.
And then,
That's what,
yeah, and then you sign it, and we forgot
Right.
that last time, but yes.
yeah, that's what I thought. So I want to make sure that we have covered all of that for our due diligence since we had a public comment. So, okay, now we're going to move on that item. And thank you, Amy. That was a lot of reading, and I appreciate having this in front of us.
And
so
I even shortened it up for you.
And I thank you for that, and I'm sure you did that for yourself as well. And I think it's pretty clear, and we know which state law that allows us to do that. So now we're going to move on to our next discussion item, which is the ACOT amended plat, which is boundary line adjustment and right-of-way vacation, file number 26-LAND 4538. And Mr. Say, I'm assuming that is you,
That is correct.
but please proceed. Thank you.
Absolutely here. Let me bring it up for you. So this is the ACOT amended plat, boundary line adjustment, and right-of-way vacation application. I will say for these amended plat boundary line adjustments typically are administrative level applications unless they have some sort of appeal with them. However, the right-of-way vacation mentioned as a part of this is something that's approved by the Board of County Commissioners, of course, which then prompts it for review. It's got a few different things moving on in terms of its working parts and pieces, so I thought it best to provide it as discussion so that I might be able to explain it, and if in the event you have questions, please feel free to ask me. So this request is a combined amended plat and boundary line adjustment for UR1 zone parcels. You can find this in the Harrison Sunny Slope Annex subdivision and the ACOT exemption subdivision, portions of which are meets and bounds for the ACOT exemption as well as an already platted exemption. I'll get into that a little bit more later. But it includes a few different addresses that are shown here along County Road 38E, as well as, I believe, Sunny Drive. The total acreage of this is 8.25 acres. So I have some renderings here and site plans that I can go back and reference here too. But overall, it's changing what are the existing lots from a total of 4 lots down to 3, making them closer and conforming to what our land use code asks for, specifically as it relates to the ones in the Harrison Sunny Slope. And here I've got highlighted different areas, this of which is being proposed as a turnaround, and this of which is being vacated within this application, or proposed to be vacated within this application. Currently, it ends and just terminates in a roadway without a bulb. Here's more of the rendering to give an idea as to what is being altered from its current condition, shown here on the right, with annotated lines that we can go back and reference as well too, to show what those differences are. Our referral agency comments that we got with this application stated no objections to the request. I have them listed in detail that we can go back over, again, should we want to. We referred this out to neighbors within 500 foot of lot lines, and we did have one individual that reached out to us regarding what was going on. I called, explained the application, and there were no further comments from that moment. This reiterates what I had just said. And the application, we've got 3 different sets of review criteria. We have a right-of-way vacation review criteria that runs A through D, as well as an amended plat criterion that runs A through E, as well as the boundary line adjustment criterion that is A through E as well. I am going to speed through some of these here. Oh, okay, they're skipped. Good. We have conditions of approval that are proposed along with the application that just state affirmatively they would need to amend anything on that final plat if needed for the final signatures, among other typical that come along with amended plats and right-of-way vacations. And I've got a motion slide here. If you had any questions, I'm open for it now.
Thank you for your presentation. Colleagues, do you have any questions? I had one.
Sure,
Can you go back a couple of slides?
absolutely. Which one were you looking for?
The one with the 2 yellow highlighted areas of, yeah, that one, great. I'm just curious, thinking about fire safety, and I know that Poudre Fire stated they had no comments for the proposed plat amendment. And so one's being vacated and there's that turnaround. And so I'm curious, when did the fire department, you were explaining how they understand that turnaround, and I'm wondering if that was, did they comment on, I looked at the report, but I'm just wondering, did they comment about being able to turn around as a fire department in that area, or is it not considered, or just wondering about that?
So the subdivision's relatively historic, and at the termination of that road, there isn't currently a bulb that would allow easy turnaround. They didn't comment specifically on there not being an existing turnaround, but I think that's by virtue of them having added what is this hammerhead depicted here underneath of my cursor to allow them then to turn around. I would suppose that's why they've not got many comments.
Yeah, that's what reason for my question was that it seems like because there was no comments, thank you for calling it, I forgot the name, but the hammerhead turnaround, that is, that obviously deemed sufficient for emergency vehicles and fire trucks to be able to turn around and do that. I mean, they're pretty apt in maneuvering those, but that seems like why there was no comments. That must have been insufficient, correct?
Yes, it creates a better condition than what currently is at the site by dedicating it,
Okay.
creating then a formal turnaround.
I just wanted to clarify that. Thank you very much. You have answered my question. Okay. So now we'll move on to, again, thank you for your presentation. Any other questions? Just want to make sure. Okay. So now we're going to move on to applicant presentation, if they wanted to present on that.
Yes, should you want to present or provide any additional information, you're welcome to come up to the podium. Otherwise, if you do not want to do so, then
Yeah.
you do not have to.
It's only 10 minutes long. You don't have to, but.
We don't have anything to present.
Okay, that's fine.
Straightforward.
Yeah, I just want to make sure you have the opportunity in case you did. So you're welcome. Okay, so we'll move on now to is there any public comment? I'll start in the room. Anyone want to make public comment? You would have 3 minutes. Seeing none that have indicated they'd like to make public comment, Ryan, would you please ask anyone online who's been joining us?
Madam Chair, we have no members of the public online.
Okay, so then I will say this public comment of this public hearing is now closed. And since there's no need for rebuttal, we won't ask the applicant if they want to have 5 minutes for rebuttal. It's really not needed at this time. So commissioners, do you have any questions for the applicant or for staff? No? Okay. So I don't have either. I just wanted to clarify and make sure that was sufficient. So you answered my question. So if we don't have any other items, then I'll ask Commissioner Stevens to make that motion, please. Unless there's deliberations, I don't know if we need to. There's no questions.
Yeah, I mean, I'll be supporting this. I feel like staff has done a good job. There's clearly a lot of criteria that's listed here, but I would say they either meet the criteria or the intent of the code, and so I'm happy to support this.
Commissioner, thank you, Commissioner Stevens. Commissioner Kafalis.
I agree wholeheartedly with the comments of my fellow Commissioner Stevens.
Thank you, sir. And so, yes, I do think it meets the criteria. I just had that clarification. You clarified that for me. I just want to make sure that was sufficient. Sometimes, you just got to dig in a little deeper. And I see that there is no opposition to this request. And all the other, there was lots of internal and external referral agencies that had provided comments. And I agree with all the conditions of approval, including the other ones that were in our addendum. So I wanted to make note of that. So I feel this applicant has met all of the amended plat review criteria, and I appreciate staff for a thorough and report and presenting concisely today. So thank you for that. So Commissioner Stevens, would you make that motion, please?
Yes, Madam Chair, I move that the Board of County Commissioners approve the ACOT amended plat / boundary line adjustment and right-of-way vacation, file number 26, land 4538, subject to the conditions of approval as recommended by staff in the staff report.
Thank you for that motion. Any further discussion? All those in favor? Aye.
Aye.
Okay, that passes 3-0. Congratulations. And with no other further business on our agenda today, we are adjourned at 3:40. Have a wonderful afternoon. Thank you for joining us.